I can hear some silence outside. I guess there's some action happening in the Cape Town CBD. Nonetheless, let us begin. Topic again, when do I take my case to court? A very important topic for the sole reason that many people do not understand how a legal court process works. And they are of the opinion, two opinions. There are two schools of thought. One school will stipulate and state that courts are not there to assist you, you'll be wasting your time, and furthermore, you might get less than what you are asking for. And obviously, these webinars dealing with family law generally, so in a child custody matter, you might come out less. For argument's sake, let's say you are allowed to see the kids every second weekend, now you want to have 50-50. Someone tells you, if you go to court, the court will find in favor of the mom or in favor of the dad, or you might get less, far less than what you want. The other school of thought believes, no, if I go to court, I get an expensive lawyer, the lawyer will get me what I want, and the court will find in my favor. I'm the mother of the child, I give birth to the child, clearly the court will find in my favor and give me what I want. That is the two schools of thought which you generally get when it comes to child custody matters. And if you ask me, I do not follow any one of those schools of thought. My view on the matter is you need to be smart. There are some benefits in going to court and some disadvantages. But the ultimate deciding factor as to whether or not you will be successful is whether or not it is the actual time to go to court. If it is not the time to go to court, and you have not done everything possible that should be done in order for you to go to court, then it's not the time to go to court. And furthermore, if you have assessed your matter, if you assess your case, and you determine and you decide, no, I should not take this matter to court because I have a good understanding with the other party, or I'm getting what is fair and reasonable, then you should not take the matter to court. You should not even take a matter to court based upon principle. Even if you believed, yes, I am getting what I'm entitled to, but I want to show the other party I can maybe get more. You should not take the matter to court. So let us unpack the situation and the scenarios. In a child maintenance matter, the general scenario would be the mother is the caregiver. Obviously, the opposite applies, where the father is a caregiver. But the mother is a caregiver. She is the one that incurs various expenditures for the minor children. They live with her. She takes them to school. She feeds them. She dresses them, etc. And the father, obviously, is the one that sees the minor kids every second weekend in the scenario. And he is the one that has to now contribute towards the minor children's expenditure while the kids are with the mother. For example, contribute towards the rental, the food, the electricity, clothing, and so on. So that's a general scenario. Now the father says, no, I am willing to pay you an amount of 100 Rand per month. I'm using silly figures here. 100 Rand per month, and that's what I'm paying you for. If you take me to court, you will get nothing. I will tell the court I am self-employed, business is bad, and I cannot afford to pay anything at that specific time. He might even say that he will declare bankruptcy, or he'll go missing, or he won't cooperate. So it leaves the mother in a difficult position because now she needs to decide, do I listen to the father, take what he says as being the gospel truth, and he can foresee the future, he knows what will happen, and if I go to court, I might get nothing, I'll be wasting my time. Therefore, although the children cost 500 Rand per month, and he offers me 100 Rand per month, I should just accept the 100 Rand and be happy with it and let him see the minor children whenever he wants to and control my life. That is not the way to deal with these type of matters. When it comes to child maintenance, and I'm a stern believer, and the law says this, each party should pay child maintenance according to their specific means. That's the law, full stop. And it is an obligation upon both parents to maintain a minor child. Therefore, even if the other party tells you, I will not pay, if you take me to the maintenance court, you should still go to the maintenance court and have your dispute resolved there. I have never experienced in my almost 20 years of practicing family law of any of those type of threats actually, turning into free children. It never happens. It's all threats. Once the father or the person who has to appear in court has to deal with the situation, he doesn't say, no, you're getting nothing. He will have to apply his mind. He will have to say, I earn so much money. He will retract his previous comments where he made, you will not get a cent from me. So therefore, If the other party does not want to cooperate, does not want to pay a reasonable sum of child maintenance in a child maintenance scenario, at that specific time, you go to the maintenance court. You do not listen further what the other party has to say. If the other party says he cannot afford it or she cannot afford it, and you know he can afford it, or you presume they cannot afford it, you're not 100% certain, still go to the maintenance court. Let the maintenance court make that decision for you. However, on the flip side, if the other party is contributing reasonably, is paying his fair share or her fair share of the maintenance towards the maintenance of the minor children, then under those circumstances, I would advise you do not go to the maintenance court. Why go to the maintenance court? There is an agreement in place. The very least you could possibly do is to have this agreement reduced in writing. So you stipulate the father will pay so much money per month, he will contribute towards the school fees, clothing, accommodation, and that all comes to so much. Alternatively, the father will pay the school fees directly, or the school fees, and the mother is responsible for the following. We dealt with the issue concerning child maintenance, when to take the matter to court. Let us deal with the issue concerning child custody. When do you take a child custody matter to court? In court, I mean the children's court or the high court, etc. Let us deal with another fictitious scenario. The parties were living together, they separated. While they were together, the father had unlimited contact with the minor kids because they live in the same home and so on. Now they separated, the father finds a new girlfriend, mother gets jealous, she says, father, you can no longer see the minor children. You irresponsible, you do not know how to look after kids. Contact should be supervised. Fictitious scenario. But it happens, I see it all the time. It comes to my desk a lot. Under those circumstances, the question is, should the father immediately go to court? My answer would be no. I do not advise you to immediately go to court. Immediately means now. Wait a day or two maybe, then you are delaying the matter. First, try to resolve this matter out of court. In the sense of urgently, maybe see a lawyer, let the lawyer send the other party a letter stipulating these are the issues, this is the issue of the matter, you are refusing my client contact unreasonably, please restore contact, failing which we will go to court, but we also put in a provision that the parties can go to an urgent mediation session. So the attorney, if he knows people in the game, and it's easy to find a mediator, go to FAMAC, FAMSA, etc. Set up a meeting urgently where the parties can sit down on the same table together and they can try to resolve this matter. Let us look at why the mother does not want the father to have contact. There could be good reasons, I do not know. All that I have is the father's version, that the reason is that he has a new girlfriend or someone else in his life. There might be other cogent reasons, we do not know. The mediation session can assist us in finding those specific reasons. If, however, the mediation session doesn't work, and it's quite soon, I do not believe people must go to court immediately if there is a dispute, because the court process itself is quite lengthy and long and expensive and laborious, and sometimes it does not resolve the issue. It makes matters worse. So if you never saw your kids for a few days, bear with the system, give it another few days, because now you are legalizing matters. You need to act immediately as well. You can't be refused contact and wait a few months and then start waking up. That's also not the way to do it. But if the correspondence via the lawyer or the mediation session did not work, or you're sending a third party, a priest, your father, your brother, your uncle, you speak to her father, and this matter cannot be resolved, you're getting nowhere, and you are still being denied contact to the minor kids or only afforded supervised contact, then at that specific time, I would advise you to approach the court to try to resolve this matter, but not before that. First, try to resolve the matter out of court before approaching the court, because once you go into the court realm, it's a total different world, and it's sometimes best to avoid that if you can. But if you are there, do your best, fight for your kids. But as I said early on, first make sure you have tried those things before trying to resolve the matter out of court. I hope this video or this webinar, short webinar, was of use to you, and good luck. And if you are in court, all the best. Take care.